Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the realm of international taxation. For this, we have selected three important cases. The first one discusses the eligibility to deduction on state taxes paid abroad. The second one discusses the withholding tax liability on receipts in the hands of foreign concern having no permanent establishment or business connection in India. And the third one discusses the attribution of gains accrued to foreign entities on offshore supplies. Our first case revolves around deduction claimed in state taxes paid overseas which were not otherwise eligible for relief under Section 90 of the Income Tax Act. Let's understand what exactly happened in this case.
The SSC company is engaged in the business of export of computer software providing e-solutions and BPO activities. During assessment, the AO noticed that SSC had claimed deduction of state taxes paid in overseas country. It was submitted that these taxes were paid in USA and Canada and such taxes did not come under the purview of Section 40 Clause A. The dispute, however, arose as the AO did not find merit in the submissions of SSC and rather observed that the expression tax under Section 40 Clause A would encompass all taxes levied on the profit or gains of the business or profession and was not limited to tax levied on total income computed under the provision of Indian Income Tax Act. Ultimately, the AO disallowed the deduction claimed on account of state taxes paid overseas.
Let's see what the tribunal had finally decided. Once state taxes paid by the Indian company to overseas are found ineligible for any relief under Section 90 of the Income Tax Act, then the same is eligible for deduction under Section 40A(2). Section 90 of the Income Tax Act did not provide for inclusion of any tax levied by any state or local authority of that country within the expression income tax. The term tax as defined under Section 2 Clause 43 of the Income Tax Act would mean only the tax chargeable under the Act. Moving on to our second case, the tribunal was approached to decide as to whether withholding tax liability can be attached upon pure reimbursements even when non-resident recipient has no fixed base or permanent establishment in India. Let's understand what exactly happened in this case.
The SSC company is engaged in the business of real estate. During the relevant AY, the SSC had made payment to various non-resident parties without complying with the TDS provision, as according to them, the payments were generally in the nature of reimbursement, hiring of aircraft and publicity expenses. Accordingly, it was claimed that these payments were covered under the exemptions available under DTAA and not chargeable to tax under Section 5 Clause 2 read with Section 9 of Income Tax Act. Similarly, provisions of Section 195 were also claimed as not attracted. The dispute, however, arose as the AO imposed a demand under Section 201 by treating the SSC company as in default for non-deduction of tax at source in respect of payments made by the SSC to non-resident recipients which according to him was in the nature of royalty or FTS.
Let's see what the tribunal had finally decided. Payments made overseas in the nature of reimbursement attract no tax at source liability. A UK resident firm which does not have any fixed base regularly in India and whose aggregate stay in India during the relevant period does not exceed 90 days is not liable to pay TDS as per Article 15 of the India-UK DTAA. Payment made overseas for publicity expenses for merely securing the ground rights so as to find other sponsors for the cricket event does not attract tax at source if non-resident payee has no PE in India. Now let's move to our last case, where profits generated by non-resident concerns from offshore supply of software and hardware are attributed in their hands for purposes of the Income Tax Act. Let's see what exactly happened in this case. The SSC is an Italian concern engaged in the business of manufacture and supply of microwave transmission equipment. During the relevant year, the SSC had supplied microwave transmission equipment, including both hardware and software components. Here, the dispute arose in respect of taxability of these offshore supplies to the telecom operators in India. The department was of the view that some portion of the profit relating to these offshore supplies should be brought to tax in India, as activities relating to installation, commissioning and maintenance required the presence of the SSE in India. As per the department, unless these activities were completed, sale could not said to have been concluded.
Let's see what the tribunal had finally decided. Liaison office authorized for mere supply of hardware components directly from overseas parent company without any assistant in installation cannot be treated as installation PE. No liability will arise to a non-resident if transaction of sale is on principal-to-principal basis and transaction of supply of components by LO are on its own account.
With this, we wrap up this episode of Legal Wrangle. Thank you for watching. Goodbye.